This is Barry Zalma on insurance. I'm an attorney who has retired from the practice of law and now spend my time as an insurance claims consultant and expert witness and author and producer of these videos. Today I'd like to talk about the need for proof of an occurrence when making a claim against an insurance policy that protects against liability of the insured to third parties. An occurrence is usually defined as accidental loss or damage which results during the policy period in bodily injury or property damage. For example, in Green v. State Farm, a 2005 decision of a Utah appellate court, a homeowner sued the insured after he sustained property damages as a result of a landslide. At the time of the landslide, the developer defendant held a contractor builder's risk insurance policy issued by State Farm. The developer initiated a declaratory judgment action against State Farm, seeking defense and indemnification under the policy. The Court of Appeals held that the lack of a claim of simple negligence scuppered the developer's case and said, quote, "Under Utah law, the scope of the risk an insurance company takes is determined by the terms of the policy, not the expectations of the insured. Absence of finding of ambiguity, we simply construe the policy according to its plain and ordinary meaning. In the present case, construing the policy according to its ordinary meaning leaves us to conclude that under the unambiguous terms of the policy, Fennell's complaint, the insured's complaint, did not include allegations that constitute an occurrence under the policy. It should be axiomatic in all third-party liability cases that before there can be a duty to defend, there must be an occurrence or accident so that the events sued upon are fortuitous. In some states, the pleading controls the decision on coverage, as in Utah, while in others, like California, the insurer is obligated to look beyond the complaint to extrinsic facts. The 11th Circuit has applied the injury in fact trigger 3 times in the context of similar occurrence-based CGL policies and latent damages for purposes of determining whether the damage occurred during the policy period or during ongoing operations. The court recognized that the 11th Circuit explicitly limited its holdings to the specific terms of the policies and facts before it. In Liberty Mutual versus Treesdale, Inc., a 2005 decision of the Third Circuit, all asbestos claims were found to have been the result of a single occurrence as used in the policy. From approximately 1966 to 1975, Treesdale manufactured and sold a product known as Sofalex, which contained asbestos. Several thousand asbestos exposure claims have been filed against Treesdale to date. The asbestos claims are typically filed by steelworkers who worked in the open hearth part of steel mills and others who claim to have had contact with the open hearth. Treesdale contends that all of those asbestos claims share a common feature: repeated exposure to asbestos, and at least one exposure to Treesdale's asbestos-containing product. The Third Circuit applied, as it had in the past, the cause of loss test that it defined as follows, quote, "The general rule is that an occurrence is determined by the cause or causes of the resulting injury. The majority of jurisdictions employ the cause theory. Using this analysis, the court asks if there was but one proximate, uninterrupted, and continuing cause which resulted in all the injuries and damages." Close quote. The Third Circuit in Truesdale found that the asbestos claimants' injuries stemmed from a common source, that is, the manufacture and sale of the asbestos-containing products, and that they therefore constituted a single occurrence. In a different scenario, in a case of sexual abuse of a minor, where the minor plaintiff in the underlying action could only give a broad time frame in which the sexual abuse was perpetrated, the court concluded that proration of liability among the insurers insuring against the liability of the defendant over the years the abuse took place acknowledged the fact that there was uncertainty as what actually transpired during any particular policy period. Inherent in the meaning of the word accident or the word occurrence is the doctrine of fortuity. Indeed, the fortuity principle is central to the notion of what constitutes insurance, because insurance can only exist if the loss that is the subject of the insurance is fortuitous. Although the term fortuity is used almost everywhere in my videos and in my books, in short, fortuity consists of two central aspects: intent and control. The concept of fortuity is inherent in all liability policies, so that a loss is fortuitous if it was not intended. A loss or harm is not fortuitous if the loss or harm is caused intentionally by the insured. For an event to be truly fortuitous, it must, of course, be accidental, because the policy only covers occurrences that are accidents. Of course, one cannot intend to commit an accident, because an accident is an event that takes place without one's foresight or expectation. Almost every policy of insurance issued in the United States excludes coverage for intentional acts. And if they do not, the implied fortuity doctrine eliminates the potential for coverage for some intentional act of the insured that causes damage. In Automobile Insurance versus Cook, a 2005 decision of the New York Courts of Appeal, the court was faced with the legal question of whether an individual homeowner's insurance policy affords coverage when that individual is sued for wrongful death after killing a person in self-defense. The facts of the case showed that on February 20, 2002, defendant Alfred S. Cook shot and killed Richard A. Barber, the decedent, after a disagreement over a business arrangement spun out of control. The decedent had entered Cook's home without permission. During their discussions, Cook, armed with a handgun, retreated to his bedroom to retrieve a 12-gauge shotgun, and then returned to the living room where the fatal confrontation occurred. Cook was indicted for a number of crimes, including murder in the second degree. He stood trial and was acquitted on all counts of the incident. The jury concluded in the criminal case that the prosecution failed to prove beyond a reasonable doubt that the 120-pound cook did not have legal justification for shooting the 360-pound decedent who had previously attacked and injured Cook after he refused to leave Cook's home. Finding no coverage, the majority held there was no possible interpretation other than the acts were intentional. In a case where the policy language does not refer to an intentional act, but rather contains an exclusion that applies to assault and or battery committed by an insured or any other person, application of the exclusion does not depend upon the perpetrator's mental state or whether the injured person was the intended victim. When the perpetrator was convicted of battery on the claimant, the exclusion applied regardless of the perpetrator's mental state. In 1978, the California Supreme Court, in a case called Clemmer v. Hartford Insurance Company, dealt with a shooting that resulted in the death of the victim. Regardless, it led to a finding by the Supreme Court of California of a need for defense and indemnity by the insurer. The court concluded that Hartford had no duties with regard to Dr. Lovelace's intentional acts in the killing of Dr. Clemmer, but was obligated to defend him. If there was a finding of non-intentional conduct in the shooting, however, it would be obligated to defend, and its refusal to do so was wrongful. One of the most extreme situations where an insured almost got coverage for an intentional act occurred in State Farm General versus Patrick Frake, a 2011 decision of the California Court of Appeal that reversed a trial court by concluding that an intentional act that causes injury, whether the injury itself was intended by the actor or not, is not an accident, nor is it an occurrence as those terms are used in a liability insurance policy. It thus concluded that the insurer neither owed defense nor indemnity to the insured. Under California law, the word accident in the coverage clause of a liability policy refers to the conduct of the insured for which liability is sought to be imposed on the insured. The term accident refers to the nature of the conduct itself, rather than to its consequences. The insured's subjective intent is irrelevant to the coverage question. In cases where an intentional act is substantially certain to cause injury, determination of an insured's subjective intent or lack thereof is not conclusive with regard to coverage. Rather, an insured's protestations that he or she didn't mean to hurt anyone are only relevant when the intentional act issue is not substantially certain to result in injury. Bad people do bad things. Forcing a woman to have an abortion, beating the woman and imprisoning her while threatening to kill her mother, cut off her fingers, and force her to act against her doctor's recommendations are all intentional and abusive conduct that is excluded by almost every policy. Even after pleading guilty to a domestic abuse crime, Nikos Hecht had the unmitigated gall to sue his insurer for not providing a defense and indemnity brought against him by the abused woman. In Nikos Hecht versus Great Northern, a 2019 decision of the 10th Circuit Court of Appeal, Hecht had pleaded guilty to domestic abuse, an act that was proved beyond a reasonable doubt. the actions of Hecht were clearly and unambiguously excluded. The allegations of the complaint, although it claims some of Hecht's acts were negligent, the use of a Mexican nurse practitioner to attempt an abortion, those acts were totally intertwined with the abusive and intentional acts, so that the negligent acts were part and parcel of the intentional criminal conduct. Intent can be inferred in certain felonious assault or rape cases where the intentional acts necessarily cause harm. However, courts should be careful to avoid applying the doctrine in cases where the insured's intentional act will not necessarily result in the harm caused by the act. Almost any injury that causes while driving under the influence of drugs or alcohol is foreseeable and arguably even substantially certain to occur, but an intent to cause those injuries is not generally inferred in such a situation because more than foreseeability or substantial certainty is required to infer an intent to cause injury. This video was adapted from my book, Zalma on Insurance Claims, Part 103, Second Edition, which is available from Amazon.com as both a Kindle book and as a paperback. If you found this video to be of interest, please refer it to your colleagues. It's free. And please subscribe to my Rumble channel, my YouTube channel, and my blog so that you can learn about future blog postings and future videos. Thank you again for your attention.